Good morning. Hope this is working. Looks like we got pretty good attendance here. We'll wait maybe 1 or 2 more minutes before we get fully started here. Let's see. Can the rest of you hear me? Okay, cool. That is good news. Yeah, Mayron, it's showing up on my screen as you have a muted microphone. Okay, well, we got a pretty good group of people now, so why don't we get started? Of course, this test is either tomorrow or Friday. So, we'll do a little bit of content as well as just sort of test strategy generally going into it. And then there was a group of questions that I wanted to go through with all of you and talk through because I think on the MPRE, it's really important to look at the wrong answers because they do. I don't want to say that they try to trick you, but they are very precise with their language. And Marilyn, sounds like that you might be coming back alive there. But yeah, so we need to just read as precisely as they're writing the questions. And sometimes it's as simple as just double checking when you read the question itself. Are they asking whether something is an okay practice or is it something that they should be disciplined for? And just remembering, okay, which are we trying to find the answer that says, yes, this is okay, or no, they should be disciplined. Okay, so
just before you get started, Stephen, I just wanted to jump in real quick. I feel something to emphasize for a last minute review that I think is a great idea is the MPRE online practice exams 1 and 2. And so if you haven't taken those yet, please spend the time to go through those because, just echoing what Stephen said, one of the best ways to study is to do questions and then review them. And the beauty of online practice exams 1 and 2 is they have detailed explanations for both the correct and incorrect answer choices. So just the process of going through those exams, I think will be incredibly useful for you down the stretch. Now, obviously, we haven't heard anything, but obviously pay attention for any notices from the NCBE. Coronavirus is impacting the LSAT administrations. So just a heads up on that, something to definitely pay attention to. And then the other thing is, if you're not sure what to spend your time on, just focus on, the things that are really heavily tested, right? And you can see that in our study guide. If you don't have the PDF, you can just tap support from the left menu and request the PDF, and we can get that sent out to you. But obviously the main testing points are the lawyer-client relationship, conflicts of interest, right? Competence, litigation, other forms of advocacy. I wouldn't worry at all about judicial conduct if you're really stressed for time or strapped for time. Another thing to put in perspective is like what you need to pass, right? So there's 60 questions, 10 are experimental, which gives you 50 scored. They say, you can assume about 3 points per question, right? And on California, for California, you need an 86, right? Which means in California, you would need to basically get 29 of the 50 scored questions correct to pass. And I hope that gives you the confidence that this is something that's very doable. And my last piece of advice before I turn it over to Stephen is just remember that the standard here is not what Jesus would do, right? So avoid the perfect answers. The trap answers, right, is generally the step one below the perfect answer, right? And with that, it's all yours, Stephen.
Okay, thank you, Mayron. Yeah, so everyone's studying journey is different. So some of you may have been using our course for the last month or two. You may have done every practice question there is and are feeling super confident. Others may have come to it a little bit later in the game and are planning on having a big day today. So just know that, like Mayron mentioned, going through those two practice exams, which I'm not going to touch today. We're going to look at some of the free questions available on the portal rather than getting into those exams. But if you put in the work and focus on those main issues, you should be all right for tomorrow or Friday. It's just sort of some housekeeping, I guess, just for the sake of reminder. It's a 2-hour and 5-minute exam. There's 60 questions, like Mayron said. 10 of them are experimental. But of course, you're never going to know which ones are experimental. So do not play that game of, oh, I think that this question might not be real, I'm going to skip it, or I'm not going to take it as seriously. Take every question seriously, because unlike the bar exam where you've got 2 days, you have 200 multiple choice, there's 60 here. So it's a much smaller number of questions, but it's also a much narrower legal focus here. Now, Mayron did mention that the standard is not the what would Jesus do standard, which I like putting it that way. But I think when you're in doubt, you want to err on the side of being more protective of your client's rights, being more careful. So when you don't know an answer, just generally go with the one that's a little bit more restrictive, but not outrageously so. And so some of you who are taking the MPRE may already be practicing in certain jurisdictions and are taking it again in order to get licensed somewhere else. So I always emphasize that, unfortunately, the MPRE does not exactly reflect the realities of legal practice. So try to, really draw from your study on answering these questions and not necessarily what you've seen inside your firm. Your screening procedures might be different. The ways that you or other associates or partners at the firm the way that they communicate with clients might be different. So just remember to kind of stick to the fundamentals of what you have learned in your study here. So what I was hoping to do here is load up some of the practice questions, and I'm sure a lot of you have already gone through those, but I just wanted to basically talk through. Let me see how many participants we've got now. Okay, so we have enough that I don't want to have a sort of free-for-all chiming in, but I would like this to be a little bit conversational. So I'll maybe I don't want to call on people, but as we get into it, feel free to chime in, and if it gets unruly, then we can set some procedures in place. But I really, as I was emphasizing before, think that looking at the wrong answers is so important on this exam. So if you will all go into the, make sure you're logged in to your MPRE account. And then let me give you instructions from there. You are going to, let's see, you're going to go to filter MPRE questions, then go down to MPRE free. And if you've already done these, then you know, the numbers at the bottom will be colored in green or red according to whether or not you got it right. So I would suggest going to the top right, clicking options, and clicking on test mode, so that you do not see the work that you had done previously. Okay, and I'm gonna leave this the chat box open as well here. So you know, chime in there or via your microphone if you've got questions as we go here. So you know, thinking that some of you maybe have just looked at a couple of these, I thought we'd start at question 10. So everybody go to question 10 of, it's out of 158. So it should look MPRE free on the top left, 10 of 58, and then it should say test mode. So I'm going to give you all just another 15 or 30 seconds here to get on board. And I'm just going to quickly address Maya's question here. So the course is organized in order of most frequently tested. So if you go back and review the first 3 or 4 lectures and sets of questions that we have on there, those will be the most heavily tested ones. But as Mayron mentioned, you know, lawyer, client, confidentiality and relationships, conflicts of interests, and litigation, other forms of advocacy. Okay, so hopefully we are all together here on question 10. Let me see if I can actually just share my screen because that might make it easier for everybody. Where's that button? Okay. I still see myself for some reason, not the shared screen. Rest of you out there, do you see my screen?
Yes.
Okay, great. Thank you. Okay, so we're on question 10. So if you weren't able to get there on the portal, we have it up in front of me here. So the attorney wants to make it easier for her clients to pay their bills for her fees. Which of the following would be proper for attorney? To accept bank credit cards in payment of attorney's fees, to arrange for her clients to obtain bank loans for the purpose of paying attorney's fees, and if a case is interesting, suggest that the client give attorney publication rights concerning the case as partial payment of the fee. So remember, like I said, we want to always ask, what is the question actually asking us here? Which of the following would be proper? So which is acceptable? And you know, you've all been looking at these questions, so we know that the answer choices we get are some combination of the various Roman numerals. So it'll be 1, 1 and 2, 1, 2 and 3, only 2, only 3, or any combination thereof. So this question is, can you accept bank credit cards in payment of attorney's fees? Well, yes, you are in fact allowed to accept payment via credit card. Arrange for clients to obtain bank loans for the purpose of paying attorney's fees. That also is all right. But then we have this number 3 here. If a case is interesting, suggest that the client give attorney publication rights concerning the case as partial payment of the fee. So I've, kind of clued up the answer for you here, but does anybody want to chime in and talk a little bit about answer choice 3 here and flesh out that rule for us?
Hi, this is Sherry. Can you hear me?
I can. Thank you.
I think it's B, because a lawyer can collect fees through credit cards. I thought it was iffy that they can arrange a bank loan, but I think that is allowed. But there is not allowed that a lawyer can negotiate literary rights or media rights during the pendency of a case or representation. So I think it's B.
Okay, and is there, you are correct, is there ever a time where you can negotiate publication rights with your client?
I think you can after the case is concluded, and that means appeal or the time for appeal has expired. I just keep thinking about the O.J. Simpson piece. So I think yes.
Exactly. So that's it. And this is a rule that makes sense. If you're negotiating with your client publication rights during the trial itself or before the trial, then there's a fear that you might act in a way that is not in your client's best interest, but in the best interest of that tell-all book or movie that you want to make or about the trial. So this rule is rooted in making sure that the lawyer continues to keep the client's best interest in mind and not some interest of financial gain for the client or some celebrity. And the OJ trial is the perfect example for this, that maybe you're trying this case and you think, oh my gosh, OJ Simpson's here, I'm going to make millions even if I lose the case by publishing a book. Obviously, as an attorney, that's not what we've got to be thinking about. We need to instead be thinking about what's best for our client. And then for number 2, I agree that's sort of a weird one about obtaining bank loans, but you can help your client obtain a bank loan. You as an attorney cannot make that loan to your client. There's actually a attorney back where I'm from in Buffalo who had his license suspended for a couple of years for basically setting up a shell company that would loan to his clients. Okay, let's go on to number 11. So attorney practices law in a state that has experienced a business recession and where several banks have failed and others are severely pressed to preserve their solvency. Attorney maintains a client's trust account in bank, and that account is insured by the Federal Deposit Insurance Corporation against losses up to $100,000. Attorney also maintains his regular office account in the same bank, and that account is insured to $100,000. During a particularly busy time, attorney's bookkeeper told attorney that the balance in the client's trust account had increased to $150,000. The bookkeeper noted that the office account had a balance of $30,000. Which of the following courses of action by attorney would be proper? So the alarm bells should be ringing here about client's funds. So number 1, leave the client's trust account as is if the balance is likely to decrease to less than $100,000 in the next 10 days. Open another client trust account in another bank and transfer some funds to the second client's trust account to maintain a fully insured balance in both accounts. Or temporarily transfer $50,000 in the client's trust account to the office account so the balance in both accounts is fully within insured limits. Okay. Anybody want to walk us through this one or talk about the first option, leave the client's trust account if the balance is likely to decrease to less than 100,000 within the next 10 days? Okay, well, basically you can't be there guessing what's going to happen with the money in your client's account. You can't say, oh, okay, there's a value greater than what's insured, but I think it's going to go down. You can't be speculating on your client's funds. Second option, open another client's trust account in another bank and transfer some funds to the second client's trust account to maintain a fully insured balance in both accounts. Right? That option sounds pretty good. It's a second account, but it's still a client's trust account, fully insured, and protects your client's money. Remember, I was talking earlier, when we're not sure, pick the option that is going to be more protective of your client. And then the third one, okay, somebody chime in on this one. Temporarily transfers $50,000 from the client's trust account to the office account, so the balance in both accounts is fully within insured limits. Okay or not okay? We have people in the chat. 2 only from Vera. I agree that is the correct answer. Anybody want to talk a little more about number 3 more? I mean, I'm happy to lecture here, but I find this more exciting if it's a little bit interactive.
Sure, I'll jump in. Number 3 commingles your funds with the client's funds. So it's pretty clear that that's not allowed.
Perfect, right? And we have this countervailing interest here where we think, oh, well, the money will definitely be safe if I move it from that client account, which is now over the insured value, into my account as an attorney that has some cushion here to handle more cash, but you can't commingle the funds. So always keep yours and the money of your clients separate. Okay. Any questions on that, or we will go on to number 12. Okay. And as I look at my coffee here, those of you who are with me on the Pacific Coast, thank you for this joining us on this special early morning edition of the office hours. Lets you get a nice full day of studying in afterwards. Okay, law firm, a professional corporation with 5 lawyer shareholders, employs 25 additional lawyers. Which of the following is or are proper? 1, employees who are members of the bar are not made shareholders until they've been with the law firm 10 years. Hold on, let me get this chat over. 2, a manager who is the office manager but not a member of the bar is executive vice president of the firm. And 3, widow whose husband was a lawyer shareholder in law firm until his death 2 years ago, continues to hold husband's shares in law firm distributed in his estate until their child completes a law school education. Which is proper or are proper? So out of these 3, do any immediately pop out as not being acceptable to you?
Hi, this is Sherry again. Number 2, that doesn't seem to be proper. But
what's the problem with number 2?
The problem is that you have a person who's not a lawyer being an officer or shareholder part of the firm.
Great, and that's, unfortunately, they don't always word it in the way that we studied, right? Saying, oh, they're a shareholder, they're a board member. But, we get this word executive vice president. Think, okay, well, that is a high managerial role. So right there's an office manager, which is a particular set of tasks that you can entrust to a non-attorney, but they can't be basically running the firm. A non-lawyer cannot regulate lawyers. Yes, also true. Those highest positions, those who are shareholders, board members, the ones who are listed in corporate documents or whatever it might be, have got to be attorneys. Okay, what about number 3? Okay, so yeah, right. And I've got the chat open. I think you can probably see that on my shared screen. But if not, go ahead and open the chat box on your computer so we can all be together here. So yeah, 3 is not proper. Again, it's a non-attorney holding shares in the firm, which is not okay. Well, what about number 1? Employees who are members of the bar are not made shareholders until they have been with the law firm 10 years. Maybe some of you who have been in practice or have been around firms, what is or is not the issue with number 1? Okay, I will answer it.
I don't think there's any issue with number 1. I don't think you have to be made a shareholder of a firm.
Exactly, right? So what are they, basically they're asking, can a law firm as a business put a restriction on when you become partner, basically? And as a private entity practicing, you're running your business and you have full discretion within the law, of course, to choose who will and will not be made a partner. Are they automatically shareholders when they join the firm? No. So the idea is that when you join a firm as an associate, you are salaried. And then if at some point you work hard enough and the partners like you enough, you'll be made a partner. And that, I think that's an equivalent term here. We can look at partner and shareholder as synonyms. And so, I've been out of law school, almost 5 years now. And I have friends who have done the big law thing who after their 3rd year said, okay, I think I'm on partner track. I'm going to stay in here so I can get some profit sharing in the future. And others who said, all right, I'm not on that track. I'm going to go to a different firm. I'm going to go to a smaller firm so that I can someday make partner, but it's never guaranteed. Does the widow have to dispose of the shares? So from what I understand, you're welcome, Ray. They could put them basically in a trust account to be paid out, or can be liquidated to pay to the widow. The issue is that she cannot hold them herself. A non-attorney can never hold the shares in the firm. So that's the rule they're looking for there, which is sort of paralleled that number 2, where non-attorneys can't be executive vice presidents. They can't be board members. Similarly, non-attorneys can't hold shares. So this is a question really about the business of running a law firm, which is a very practical concern. And perhaps some of you will be running your own firms and will be making these decisions on your own pretty soon. Okay, number 13. Attorney who was recently admitted to the bar has been appointed by the court as counsel for Deft, an indigent defendant charged with a felony. After consulting with Deft and attempting for 2 days to prepare the case for trial, attorney became convinced that he lacked the knowledge and experience to represent Deft effectively. Which of the following would be proper for attorney? So, 1, request permission of the court to withdraw from representing Deft because attorney knows he is not competent to handle the case. 2, request the court to appoint experienced co-counsel and grant a continuance to enable co-counsel to prepare the case. Or 3, explain the circumstances to Deft, and if Deft consents, proceed to represent Deft alone to the best of attorney's ability. Okay, Devin, thank you for chiming in on the previous one. So yeah, perhaps part of the issue there is that holding those shares until the child completes law school would take too long. Okay. So number one, do we think that requesting permission to withdraw because the attorney knows he's not competent, do we think that is proper?
Yeah, you can do that. And I think you can do 2 as well.
Right. So there are certain rules when you are not somebody who's competent in the area, right? So number one, you say, hey, court, I tried, but I do not think that I can represent this client adequately. That's what we want. We want a truthful, a forthright attorney who's not going to represent a client that he has no business recommending. And I think in particular, this is the court, recently admitted, appointed by the court, an indigent defendant charged with a felony. So this is likely some sort of issue the attorney's never tried before. So maybe thought, oh, actually, I can learn this, right? Because one of the things is if you're not competent, but you have the time and ability to become competent, then you may bring the case. Okay, how about 2, request the court to appoint experienced co-counsel and grant a continuance to enable co-counsel to prepare the case.
Yeah, you can get assistance with a case with a more experienced or a lawyer who has specialty in a particular field that you don't feel competent in.
Exactly. So one of the options is to make sure you've got the time to get yourself educated and up to speed in that particular field. One of the other options is to work with an experienced co-counsel, right? Work with somebody who already is an expert in the field, learn under them, and then perhaps the next time that type of felony is handed to the newly admitted attorney, that attorney would be able to handle the case on his or her own. Now, number 3, explain the circumstances to DEFT, who's the indigent client, and if DEFT consents, proceed to represent DEFT alone to the best of attorney's ability. Is that all right?
I don't think that's okay, because then you're actually, I don't think a client can consent to incompetent representation.
Exactly. And that's one of those, client friendly rules is, we need to remember that as attorneys, we know more about the law than our clients, and that there are certain standards that we need to uphold that a client cannot agree out of. So just because you see this big money case and your best friend in the world wants you to represent them, well, if you don't know anything about that field of law, you can't take client consent and then go and try the case yourself. This is a rule that's there to protect the clients, really protect the clients from themselves here, right? Because there is a temptation, and I'm sure many of you have had this, where your friends call you or come to the firm or say, oh, when you get out of law school and pass the bar and everything, you're going to represent me in this issue. And you're going to say, well, no, if I know nothing about it, I'm not going to be the one that represents you, even if you want me to be. It's just sort of a unique part of lawyering, but the rules are meant to save our clients even when they might want to act not in their own best interest. I appreciate you all chiming in here. Okay, while an assistant district attorney, Attorney Alpha was in charge of the presentation before a grand jury of evidence that led to an indictment charging 32 defendants with conspiracy to sell controlled drugs. Shortly after the grand jury returned the indictments, Alpha resigned as assistant district attorney and became an associate in the law office of Attorney Beta, a sole practitioner. At the time of such association, Beta was the attorney for DEFT, one of the indicted co-defendants. Is it proper for Attorney Beta to continue to represent DEFT? So this is one of those yes, yes, no, no questions. So I guess some of you may have just seen the answer, but is it proper for Beta to continue to represent DEFT? So on questions like this, where it's a yes, yes, no, no, I always try to say to myself before I look at the answers, is it yes or is it no? And then if I already have also my reason why, that's even better, because then I'll find the answer very quickly. But it's beneficial to go in and already 50-50 it for yourself by getting rid of the yes or the no, depending. So is it proper for beta to continue to represent deft here? Anybody want to say whether yes or no beta should
No, it's not
continue?
proper.
No.
No, not proper. Exactly. So what's the issue here?
There's a conflict of interest from the previous representation as a district attorney to
Right, and
now using the knowledge that you acquired as in your position as district attorney to represent the defendant.
Exactly. And we get this key phrase here, in charge of the presentation before a grand jury that led to this indictment. So it's not like Attorney Alpha was somebody sitting on the sidelines, somebody who had nothing to do with this case. This is actually somebody who was intimately involved with the case. So no, it's not proper. And let's see, we'll click, oh, I didn't want that to happen. My apologies. So no, unless Alpha agrees not to participate in the representation, or no, because Alpha had substantial responsibility for the indictment.
It's D.
It is
D. Yeah.
D, yes. So Alpha had substantial responsibility, right? There are some situations where you can screen out, but this is not one of those. This is somebody who was intimately involved in the case and surely acquired some sort of knowledge that could prejudice the proceedings in one way or another.
Excuse me, could this also be what they call disputed or imputed, sorry, disqualification? Because
Exactly,
now
yeah.
the firm? Okay.
Right, and that's why that's why C isn't the right answer. So unless Alpha agrees not to participate in the representation, you think, okay, well, Alpha and Beta now work together, but let's just have Alpha stay away. But this is a situation where that conflict is in fact imputed to Beta. And if you think about this one in a practical sense, I mean, it's a firm where Beta was a sole practitioner. So now it's just the two of them. It's Alpha and Beta. So that risk of conflict is extremely, extremely high, because the only other attorney at the firm that Beta would have to talk to about this issue is in fact Alpha. Okay, cool.
I have a question.
Yep.
So can, in that circumstance, presumably the defendant could consent, could give informed consent in writing, and then the attorney could, not Alpha, but the other one could act to continue the defense? Is that correct?
I believe that is correct. And that's so one of the things that makes this test hard is there's this sort of what you can read into an answer as having already happened and what you can't assume happened, right? So because we don't have the information that says that the client and both parties agreed to that in writing that there wasn't a conflict, we can't assume that that happened here. But yeah, that would be, one of the ways to get around that rule. Okay. Yeah, and Ray, I see your point there. This is, another one of those examples where we're not looking for the Jesus answer, but we are always trying to take the side of of protecting our clients, because our clients can't necessarily always do a great job of protecting themselves. Okay. And I'm just clicking random ones so I don't accidentally clue to you all what the answer choice might be. Okay. Attorney filed an action on behalf of client for breach of contract. In fact, client had no legal basis for the suit but wanted to harass defendant. In order to induce attorney to file the action, client made certain false statements of material fact to attorney, which attorney included in the complaint filed against defendant. At the trial of the case, client took the stand and testified as set forth in the complaint. The trial court ordered judgment for client. After entry of judgment, client wrote attorney a letter marked confidential, in which client admitted that she had lied to attorney and had testified falsely. Upon complaint of defendant, who claimed attorney had knowingly used false testimony in the case of client v. defendant, disciplinary proceedings were instituted against attorney. Is it proper for the attorney to use client's letter to attorney in attorney's defense in the disciplinary proceedings? Okay, so there is a lot going on in this question. So the first thing that jumped out at me was that the client had no legal basis but wanted to harass. We know that you can't bring a case just to harass the other party. However, this client made certain false statements of material fact to the attorney. So as far as we know, the attorney did not know that this case was being brought just to harass the defendant. The attorney thought that there was a legitimate reason to bring this case. So the client takes the stand, testifies in line with the information that the client had provided for the complaint, but then the attorney gets this letter, confidential, and the defendant says, hey, attorney, you knowingly used false testimony, and then the attorney is facing disciplinary proceedings. Okay, so can the attorney use the client's letter to attorney in the attorney's defense here? And so this will be another, I believe, yes, yes, no, no, right? So let's start there. Yes or no, can the attorney use the client's letter and the attorney's defense in the disciplinary proceedings?
Yes.
Yes, right? So this is one of those narrow exceptions where you can break the confidence of your client, break that attorney-client confidentiality when you need it to save your own skin. So this is, it doesn't happen a lot, but if you're going to get in trouble, if you're being disciplined by the bar when your career is at stake, then you're allowed to use those confidential communications in order to say, hey, no, I didn't know that any of this information was false when I presented it to the court. Okay, so we have A and B. Yes, if it's necessary to do so in order to protect attorney's rights, or yes, because the client had committed a fraud on the court in which the case was tried. And we already talked through this. So it is A, protecting the attorney's rights. Committing a fraud on the court is not reason enough. The attorney can't just go running to the court afterwards saying, oh, look at this letter my client just sent me. But once these disciplinary proceedings are put in motion against the attorney has the right to then defend his or herself there.
Yeah, I have the same question that Marjan has, which is, my understanding was if there's a fraud perpetrated upon the court that wasn't obligatory, you have to rectify that fraud.
No, from what I understand the rules to say, if you are aware or should be aware at the time that the fraud is committed, then you have a duty. But if it's something that is discovered later on, you do not have an obligation to go to the court, sort of your own volition. Good question though, and you would not report this to like the court or the bar. If anybody Marianne, it would be to the court, not to the bar, because this is about it's about the case itself, right? It's not about, the bar exists for attorney regulation and discipline. So you don't have to go and say, oh, I did everything right, and then I discovered that there was this other information. And so, retrospectively, what I did was not right. All you can do is work with the information in front of you at the time that you are bringing the case. Good questions, everybody. So we're going to go through a few more here, and then I'd like to open it up a little bit just for the last 5 minutes or so on any broader questions that you might have, or little things that are tripping you up. And we've got good participation, both speaking and on the chat, so we can work through some of those issues together. And I appreciate people chiming in with rule numbers when they do have the relevant ones in front of them. So I always say it's hard to remember off the top of your head a number. It's like when you're in court, the judge wants you to tell exactly the where in the code it is, 312.14A5. It's a lot easier to remember what the rule is than exactly the number that associates with that rule, unless you're fortunate enough to have a photographic memory, which I do not. Okay, so we got a judge question. The judge is presently serving on a state intermediate appellate court. This court, in opinions written by her, has decided several controversial cases in which the court has held that the 14th Amendment to the United States Constitution does not guarantee due process protection to state prison inmates who are disciplined by prison authorities for violating the prison's rule of conduct. Judge is now a candidate for election to a vacancy on the state Supreme Court. She is vigorously opposed by several organizations concerned with the conditions under which prisoners are incarcerated in the state's prison. Judge is scheduled to be interviewed on television and has been informed that questions will be asked of her concerning those decisions and her attitude on the subject of prisoners' rights. Which of the following is it proper for a judge to say during the interview? So as Mayron mentioned in the beginning, this is a topic that is asked less frequently, but perhaps those of you who are political junkies and have followed some of the theatrical hearings of the past few years. Okay, so what can the judge say? I believe the issues raised by the organization opposing me are appropriate matters for legislative consideration. In my opinion, incarceration for the commission of a crime carries with it a loss of civil liberties in prison discipline proceedings. Or I am convinced I was right in those cases and will make the same decision in similar cases in the future. One only. Right, so I look at these and, part of this, sometimes the answer is going to jump out to you right away of what's right and what's wrong. Sometimes you got to work at it a little more. So number 3, I read and said, well, that definitely doesn't feel right to say I'm convinced I was right in those cases and will make the same decisions in similar cases in the future. No, you absolutely cannot in any like public setting as a judge say, oh yeah, I'm always going to decide a certain way on these cases. No, every case is unique. Every set of facts is unique. You can't have a judge that is going to decide the same issue the same way every time. And that, speaking of the political process, that's often something that happens. A president appoints somebody to the Supreme Court thinking that they're going to always, we'll say, decide 14th Amendment cases like they did when they were on the circuit court. That might not be the case. Can't make opinion statements or statements about future judgment. Exactly. Appropriate matters for legislative consideration. So answer choice 1, which is here the only acceptable one, the only acceptable answer, that's basically the equivalent of saying nothing, right? So I believe the issues raised by the organization opposed me are appropriate matters for legislative consideration. That's saying nothing. It's saying, yes, these are issues that people should talk about. The judge is not, the judge is deflecting, right? This is appropriate for legislative consideration. I'm not going to tell you what I think about it, and I'm not going to tell you how I would decide it. Okay, we will do probably 2 or 3 more here. Is 2 the only part? Death or substantial injury. Is it discretionary or a must disclose? Okay, let's go with Ray's question first. I always find this one to be hard. Is 2 the only part? Well, no. So as we discussed, 2 and 3 are both improper. Can't give your opinions. If you read 2, you see how that's sort of a judicial opinion on what the law says or how the law should be enforced. Incarceration for commission of crimes carries with it a loss of civil liberties. So they're saying, I believe that when you're incarcerated, you lose your civil liberties. That is something that a judge cannot go out and say. A judge really can't say much. I know Ginsburg got in trouble a couple of years. I'm trying to remember what exactly she had said, but yeah, judges basically can't talk to the public about anything regarding their judging. They can go and actually Ruth Bader Ginsburg spoke to my graduating class at Georgetown, and she just talked about what it was like being a woman at Harvard Law when she was there, and sort of the stops on her career and her relationship, her life. She did not talk about how she might decide future cases. And right, so to prevent death or substantial injury is a may, which I know is counter to what we might think, but again, we err on the side of our client's confidentiality. Okay, let's see, 17. This is a good question, I think. Attorney was formerly employed by insurance company as a lawyer solely to handle fire insurance claims. While so employed, she investigated a fire loss claim of claimant against insurance company. Attorney's now in private practice. Assume the claim's not been settled, and claimant consults attorney and asks attorney either to represent him or refer him, to another lawyer for suit on the claim. Which of the following would be proper for attorney to do? Okay. Refuse to discuss the matter, represent the claimant, refer the claimant to an associate in her law firm, provided attorney does not share in any fee, or give claimant a list of lawyers who attorney knows are competent and specialize in such claims. So, okay, let's break this down. What attorney used to be employed by the insurance company on fire insurance claims. She investigated a fire loss claim of the claimant against insurance. The claim's not been settled, and the claimant now consults the attorney. Okay, asked to represent him or referred to another lawyer. So this is an attorney who's already been involved in the case, but on the opposite side. So what is it acceptable for the attorney to do in this situation? Well, we might start with, of these 4, what's definitely not acceptable?
2.
2, right? You absolutely cannot represent the claimant. In no situation can you switch teams at halftime, basically. You can't represent the company and then go out on private practice and go hop onto the other side of the V. That is not okay. Can you refer to an associate in your firm, provided the attorney doesn't share any fee?
No.
No, right? So this is an imputed disqualification. And as Mariana said over there, the claim's not settled. I mean, this is still ongoing. So the firm absolutely, you can't touch it. Stay away. Can the attorney refuse to discuss the matter?
Yes.
Yes.
Yes, right? And so, when we talk about wanting to always be on the side of your attorney, or sorry, on the side of your client, there are still occasions where you need to just say to the person asking your advice, hey, I can't talk about that, right? Because here, you got to remember that there's different clients at issue here, right? So the claimant, that is, we'll call the new client at this firm that attorney has gone to, but former client, the insurance company, that confidentiality that the former client, the insurance company, and attorney had is still valid, especially because the case is still going on. Or then 4, give claimant a list of lawyers who attorney knows are competent and specialize in such claims. That's also okay, right? So you can basically say, hey, I'm sorry, I cannot discuss this with you at all. Here are some attorneys who are competent and specialize in this field. So that's kind of the one step beyond saying nothing, is to say, you know what, here are people who maybe can help you out. And that is not prejudicial to your former client. And, we always want people to be represented to the absolute best ability. So while you might think, oh, well, is he prejudicing his former client by providing a list of attorneys who are incredible in this field? Well, no, we want the best, most robust representation for every client out there. That is in the best interest of our judicial system. Okay, we've got just a couple minutes left here. Are there any general questions or issues that that people have or would like to discuss here before we embark on our final day or two of prep? Right, we're all ready.
All right, well, I just wanted to jump in real quick and just go over a couple of things that people asked here about, where to get the PDF study guide from. And I just want to make sure everyone knows how to access the MPRE online practice exams. So I'm going to...
yeah, I can unshare my screen, Mpre, and let you take over.
I just want to share.
Yeah. Thank you, everybody, for joining with us today, and best of luck.
Thank you so much, Stephen. Appreciate your time.
Absolutely.
All right, so here we go. Let me share my screen now, and let's make sure that's okay. Great. So, so this is the. Oh wait, hold on. It's not coming through? Can you guys see my screen? Do you guys see my screen?
No, I think we still just see you, Mpre.
Let's try that again. All right, I think I got it. All right, so I'm in the MPRE program here, right? And I just want to point out a couple of things. So if you don't have the PDF of the study guide and you want it, just literally come to the left menu, tap on support and say, can I get the MPRE PDF, right? And the beauty of saying that is you don't even need to wait to get a response, because as soon as you send that, you're going to get an automatic response with the PDF attached, so you can use that right away, right? Again, it's the same outline, same study guide, just if you wanted to print it up. The other thing, if you're not sure about the MPRE questions, you could say, where are the MPRE questions, right? Same idea. It's going to give you an automated response that's going to explain to you how to get them, as well as how to buy them. Because remember, OPEs 1 and 2 are paid exams that you can purchase from our store, right? And then just so you guys can see, to access them from the full course screen, you just want to tap on the filter in the top right-hand corner, navigate to MPRE questions, and there you will see OPE 1 and OPE 2 at the bottom there. Now, if you want to take them as a practice exam, you're more than welcome to. If you want to take them in study mode and review each question afterwards, either way, I think is really beneficial. I think this is, again, the best use of your time down the stretch if you are wondering how to spend today or tomorrow. And with that, I think that will bring our first MPRE office hours to a close. Who would have thought? All right, guys, best of luck tomorrow is Thursday. Tomorrow and Friday. Sorry, I'm not used to the MPRE being on 2 days. It's quite strange to me. I think this is the first time, right? But yeah, thanks again, Stephen. Appreciate your time. And again, if you have any questions, anybody, please don't hesitate to reach out to us. As we always say, we serve at your pleasure.
Good luck, everyone.